The Defendant's Guide to Probable Cause. Probable cause is a legal standard of evidence that police officers must have in order to arrest someone or obtain a warrant. If the police did not follow the probable cause requirement, you may be able to have evidence against you excluded from a court proceeding. Here's a quick guide. What is the definition of probable cause? The term probable cause refers to the level of certainty that police need to have in order to legally arrest someone for a crime. It is defined as enough evidence for a reasonable person to believe that the person had committed a crime, was currently committing a crime, or was about to commit a crime. To legally arrest someone, a police officer needs to have a good faith belief that the person they arrest has committed a crime, and they have to have sufficient evidence to support that belief. What is a probable cause hearing? The term probable cause hearing can refer to two different types of hearings. Under Texas law, if a police officer arrests someone without a warrant, a probable cause hearing must be held within 48 hours of the arrest. During this hearing, the judge will decide whether probable cause exists to support that arrest. The other kind of a probable cause hearing happens after the prosecution has filed charges. Depending on the court you're in, your attorney may have to request this hearing. A judge will hear an explanation of the allegations against you and may hear testimony to determine if probable cause exists for the case to move forward. What is a probable cause declaration? When a police officer applies for an arrest warrant or a search warrant, the officer will submit an affidavit or sworn statement that provides a brief summary of the facts that support a probable cause determination. A judge or magistrate will review this summary and decide whether probable cause exists for a warrant to be issued. In some states, like California, the statement the police officer submits is called a probable cause declaration. How does probable cause affect police from a legal standpoint? Probable cause affects police from a legal standpoint because it defines the amount of evidence an officer must have before making a warrantless arrest. It's also the required level of certainty for a judge to issue a search warrant or an arrest warrant. If officers don't have enough evidence to prove probable cause, a judge might invalidate an arrest or refuse to issue a warrant. A judge must find that there was probable cause for the officer to make a lawful arrest for the case to move forward. What is probable cause for a DWI or DUI traffic stop? What is probable cause for a DUI or DWI traffic stop? For a police officer to pull you over to conduct a DWI or DUI traffic stop, they do not need to have probable cause that you have committed a crime. Rather, they only need to have a reasonable, articulable suspicion that you have violated the law. Reasonable suspicion is defined as sufficient evidence for a reasonable person to suspect that a person had committed a crime or traffic offense, was currently committing a crime or traffic offense, or was about to commit a crime or traffic offense. To justify a traffic stop, the officer must have a reasonable suspicion that there is more than a mere hunch. An officer must be able to point to specific, articulable facts or circumstances that created a reasonable suspicion of violation of the law. Officers commonly use speeding, failure to signal a lane change, or the failure to maintain a single lane of traffic as a reason to pull someone over to start conducting a DWI investigation. What does a police officer need to conduct a DUI or DWI traffic stop? To conduct a DWI or DUI traffic stop, the officer only needs a reasonable suspicion that you're driving while intoxicated or violating any other traffic law. An officer cannot arrest you for a DWI without probable cause that you were driving while intoxicated. Do I need a criminal defense lawyer near me? Well, if you've been arrested or charged with a crime, it's essential to consult with a criminal defense lawyer as soon as possible. An experienced attorney can review the circumstances surrounding your arrest to determine if the police followed the required probable cause standards. If the police officers violated your constitutional rights while investigating and arresting you, a knowledgeable attorney can get evidence against you thrown out, or in some situations even get your case dismissed. While it might seem most convenient to hire a criminal defense lawyer near you, it's crucial that you choose an attorney who regularly defends clients in the court where you've been charged and is familiar with its practices and prosecutors. If you have any questions, call or email us anytime. At Attorney911, we defend people like you every day and sincerely want to hear your story. Thank you for watching.